Hello everyone, today we are going to discuss about intellectual property, one of the segment in capital flow. Hope this session would helpful to understand about intellectual property clearly. What is intellectual property? Intellectual property is the result of creativity, be it your own quote or design. We respect it as you do. Ensure to bring it to the world to stand out of the crowd. It takes lesser efforts to be peculiar with your creativity, such as inventions, literary and artistic works, designs, and symbols, names and images used in commerce. Under intellectual property, many services are there: trademark registration, trademark rectification, trademark renewal, trademark objection, trademark opposition, patent registration, provisional patent, design registration, copyright registration. What is trademark registration? A trademark generally refers to the brand or logo, taglines, captions, business name, etc. needs the trademark registration. It is the visual symbol which is used by the owner of the trademark for goods or services or another purpose for commerce of trade to discriminate it from another similar goods or services originating from different businesses. It is used by manufacturers or service providers to identify their own products and or services from many others easily. It is used to discriminate the owner's products or services from goods of its competitors. Trademark registration permits owners to easily establish their right to the trademark in court and get royalties. The best example of trademarks: Pepsi and Coca-Cola are two trademarks of the same industry. The trademark helps to recognize the source of the goods as well as a hint of quality. Authorities who register right the authorities such as the Controller General of Patents, Designs and Trademarks and the Ministry of Commerce and Industry. Also, the Government of India registers the trademarks in India. Trademarks are registered under the well-known Trademark Act, 1999. The trademark owner possesses the right to prosecute for damages when violations for trademarks take place. If any trademark is identical or similar to a prevailing registered trademark is applied for trademark registration, then it cannot be registered as it may cause confusion with the original trademark. Who can apply for trademark registration online? The application for trademark can be made by any person who is an individual, company, proprietor or legal entity claiming to be the owner of the trademark. What is validity of trademark registration in India? Once the trademark registration is done, it is valid for 10 years from date of filing and can be renewed from time to time. Types of trademark in India. Various forms of trademark are as follows. 1. Product mark. Product mark helps to identify the products or goods in place of services. Here the product is the unique selling feature of the company. In the beginning, the product marks are represented by trademark, which states that the mark is not yet registered but it is in the process of registration. Once they are registered, they have to use registered to give it recognition in the market. This is common practice applicable to all types of trademarks. Examples: Pepsi registered, Maggi registered, etc. 2. Service mark. This type of trademark is used to recognize and differentiate the services rather than the goods, product provided by any enterprise. The service marks have their particular character which is SM. A very prominent / most common example is McDonald's, which is a service mark for restaurant services. 3. Collective mark. As the name suggests, these marks are related with a group of people and not one single product, service. These trademarks are mainly owned by an organization, institutes or any association that is related to several members. Examples are like CS device is used by the members who fall under Institute of Company Secretaries. 4. Certification mark. This is produced to show the standard of a company, i.e., it is to show that a trader's goods or services are certified as they are meeting particular required standards. Example: wool mark, ISI, etc. is the finest example of certification mark. 5. Shape mark. Pattern mark. Here pattern is able to differentiate between the products. 6. Sound mark. It is introduced for registration of sound graphics that discriminates the products and services of one from another. Example, Nokia tune. Advantages of trademark registration. Benefits of registering a trademark are as follows. 1. Legal protection. 2. Goodwill, trust. 3. Brand value. 4. Business opportunity. 5. Unique identity. 6. Exclusive rights. 7. Power to transfer trademark to other for consideration. Process and time frame. Easy steps to be followed for trademark registration and time required to complete such a registration is as follows. Step 1. Trademark search, approximately 1-2 working hours. Step 2. Authorization drafting, approximately 1 working day. Step 3. Make a trademark application, approx. 1 to 2 working days. Step 4. Trademark registration, approx. 18 to 24 months. As a remedy for rectification of error or omission, there are provisions prescribed under Trademarks Act to rectify details submitted in application. Rectification of trademark is possible prior to registration and post-registration as well. On rectification, before the trademark is registered, an applicant can file a request for correction or amendment of a trademark application by filing Trademark Form Trademark M along with the prescribed fee and supporting documents. This is basically done when there is correction of clerical error or for a minor technical amendment required due to a mistake in filing and data entry, but no substantial alteration or amendment in application may be permitted which may substantially alter proprietary details, specification of goods and services as to the use of the mark. The owners many times ask whether they can change the word mark or the logo or color specification in logo. However, these changes fall under substantial changes and therefore not allowed. The permitted changes are more of clerical error. For example, a word mark which is a data entry error on part of applicant. Such changes are allowed but we cannot seek addition of logo or its design in the same application. For that purpose, a fresh application is filed. Whether the sought change is substantial or not is decided by the registry itself considering the application, facts and supporting documents, if any. Here, we are providing a general list of permitted and non-permitted changes. Under the Trademarks Act, the changes would be allowed if 1. The amendment does not alter the use. 2. The date of usage is not altered. 3. Details regarding goods and services must not change with the amendment. Permitted alterations. These changes do not alter the nature of the application. Changes like change in address of the applicant or in the service address, deletion or confinement of any item in the specification of goods, services, confinement, limitation in sales of goods, services. Division of multi-class application is permitted. In case of change due to an error in data entry, the trademark officer after verification of relevant document can make a change in the system along with the remarks to this effect. The registry may also direct for the amendments in application filed after its examination. Non-permitted changes. Changes like following will alter the substantial nature of the application and therefore it is not allowed. Change of word mark, logo and its color specification. Change in user date claimed. Change of type of trademark. For example, an application filed for word mark cannot be changed to device or label, as discussed with example above. Change in class of trademark. Change in trade description of mark. Here the registry may direct the changes in few situations but whether to adopt the changes sought by the applicant is the discretion of the registry. These are few of examples where rectification is not allowed. In such case, the applicant can make a fresh application of registration. Pre-registration rectifications can be initiated by the applicant himself, in situations he or she wants to clarify or correct an error made while filing the application. The registry might send back the application for rectification if any errors or omissions are detected. Such applications are marked formalities check fail by the authority. The registrar sends the application back to the applicant along with the reasons why the application is not accepted for the next stage of trademark registration. The applicant can rectify the trademark application and resubmit it with the registrar. Post-registration rectification. Once the trademark is registered, there is a different provision that governs the alteration of registered trademarks. The registered proprietor needs to file Trademark P along with the modified, amended trademark depicting how the trademark would appear after the modification. In case there are certain amendments that are required after the trademark has been registered, then the corrections can be initiated by the applicant himself, in situations he or she wants to correct errors and certain details through amendment. For example, change in place of business, change in the name of the company under which the mark is registered under, etc. This is also permitted, and the discretion of the registrar. Trademark rectification procedure. The rectification application can be filed by applicant in concerned form, that is, Trademark M or Trademark P with supporting documents. The mode of application can be online or physical filing by payment of prescribed fee. The application once filed will be scrutinized by the registry. Officer in charge may seek any clarification or supporting document to prove the genuineness of the application. Conclusion. Rectification becomes an additional burden on the applicant as well as the registry. It also delays the trademark registration process, adding the unnecessary processing period for the registration. Therefore, the trademark registration application must be filed with utmost care to prevent any errors during filing. In order to prevent the rectification or cancellation or removal of a registered trademark from the register, proper precautions must be taken during its filing and getting it renewed from time to time, taking measures to secure the distinctive character of the mark and not abandoning the mark. What is renewal of trademark? Trademark is a distinctive sign which distinguishes a good or service coming from a particular person or enterprise. Trademark registration is one of the types of intellectual property protection, where a word or visual symbol that a business uses to identify its products or services and distinguish it from the similar goods and services coming from different business is protected. To register a trademark, an application in prescribed format is filed with the concerned registrar. After getting the application, the registrar, after processing the application, it is satisfied, registration is provided under Trademark Act. A registered trademark is valid for 10 years. Before expiry 10 years, trademark owner needs to pay a renewal fee in order to continue the trademark of next 10 years. If the registered trademark expires, it is required to be renewed. Procedure for renewal of trademark. Not less than 1 month and not more than 3 months before the expiry of 10 years of trademark registration. If the registrar does not receive any application from the proprietor or his agent of a registered trademark for its renewal, the registrar shall intimate the owner about upcoming expiration of the registered trademark. The proprietor of the trademark or his agent needs to file an application to the registrar for renewal of trademark in the prescribed application form. The application must be filed on or before 6 months from the expiration of the registration. Along with the application, the proprietor needs to pay trademark renewal fee as prescribed, failure of which will lead to the removal of the trademark from the register of the registrar. Consequences if renewal of trademark fails. From renewal of trademark fails, in case of non-filing of application or not paying renewal fee, will lead registrar to remove the trademark from the register. Before removing the trademark from the register, 3 registrars will first advertise his intention via notice to remove in Trademark Journal. All the license and assignments of a trademark also expire with the expiry of registration. Trademark restoration. In case of renewal period has expired and no application has been submitted, the registration expires. However, Trademark Act allows the proprietor of the trademark to file the application between 6 months to 12 months from the expiration of trademark. The applicant needs to file the restoration application in the prescribed form with prescribed fee. After receiving the application for restoration, the registrar will advertise the trademark once again. The advertisement is given to inviting objection from people who believe that trademark shall not be renewed or restored. If no objection is received from the public within the specified time period, the trademark is entered into the register and trademark is registered for next 10 years. What is a trademark objection? Trademark application for registration made can be rejected by the authority on various grounds if they feel for such reasons. This may be for the reason that if the word or logo is too like to a prevailing trademark/symbol/logo, and if they register the same it could offend or likely to cause confusion with an existing trademark. Who is authorized to issue trademark objection report? The trademark inspectors employed or appointed by government at trademark registry issues the examination report. What are the general objections raised in trademark objection report? The most common objections raised in examination report are those likely based on the descriptive nature of the trademark or with respect to likeness or alike or similarity of the applied trademark with other marks previously existing on trademark registry record. What is the deadline to file reply for trademark examination report? The period limit to file trademark objection reply is validly 1 month from the date of publish/issuance of the response from the authority. Who can file a reply? The reply may be straight away filed by an applicant, but it is always desirable to go for professionals who have better supporting it with relevant case laws. Any form to be filed along with fees, in case there exists an objection in trademark report which requires an amendment to the trademark application to be filed. All we need to file that amendment by way of filing a form in trademark 16 with prescribing fees. Reasons to response on such a trademark objection. 1. Probable clearance. If you reply to the objection with clear proof as regards to the uniqueness of your trademark, the chance of clearance of your application is high. It also supports your application with a valid reason, and so there's no reason for your application to be rejected or get cancelled on the objection made. The clarification so sought by the registrar should be done early as possible. 2. Brand protection. Till the time of the objection, the usage of the symbol is allowed and clients use it for a few months. The consumers would have become familiarized to the brand name. In spite to objection reply, filing a new application would make no sense. Instead, simply recognize the various reasons for your logo, slogan or brand name to be different from the one already registered and get it cleared. 3. Process for trademark objection from company's end. The average time taken to draft and file a trademark objection reply is about 5 to 10 working days, subject to government processing time and client document submission. If the registrar does not accept the preliminary response, an interview is scheduled for arguments as to why registration for the applied trademark to be allowed, which may create confusion among the public at large. Here, client is to defend need itself with a valid and strong proof, after which if the government is satisfied with the response, the objection will be lifted within 18 months. Documents required for the trademark objection is logo or the trademark, name and address of the trademark owner, classification or trademark class, trademark used in state. Trademark opposition. Trademark registration is a type of intellectual property protection, under which a word or visual symbol used by a business to distinguish its goods or services from other similar goods or services originating from a different business can be protected. To register a trademark application must be filed by the applicant with the relevant trademark registrar in the prescribed format. Once a trademark application is filed, The Trademarks Registrar would process the application and issue an examination report. Among the outcomes, the Trademark Examination Report could allow for the trademark application to be advertised before registration or raise an objection for registration. In cases wherein the Trademark Registrar approves an application for advertisement in the Trademark Journal before registration, any person in the public is allowed an opportunity to oppose the registration of the mark. If a person or business entity feels that registration of the mark would not be fair, in such cases, a trademark can be opposed. On filing and trademark opposition, the trademark applicant is required to file a counter with the Trademark Registrar within 2 months. Republic is the leading business services platform in India, offering a variety of services like company registration, trademark filing, tax registration, tax filing and capital syndication. Republic can help you file a trademark opposition or respond to an opposition raised by a third party. The average time taken to file a trademark opposition notice is about 5 to 10 working days, subject to government processing time and client document submission. Get a free consultation on filing a trademark opposition or responding to a trademark opposition by scheduling an appointment with an Republic advisor. Important aspects of filing trademark opposition. Respond professionally. It's important to discuss the reason for raising a trademark opposition with a professional and deciding on a course of action. An experienced professional can significantly improve chances of successful protecting a registered trademark. No more, no guarantee. Filing opposition for a trademark application does not guarantee that the mark will be prevented from registration. Trademark registration is a process and the verdict on registration is provided only by the Trademark Registrar, based on the facts and premises of each case. Hence, our professionals can only make best efforts based on expertise. Timeline. Post-filing of a trademark opposition, it is important to periodically check the status of the trademark application until its processing on the government side. Trademark opposition requires various time-bound response or action from the applicant and opposing party. Hence, it's important to continually check the status of the application and take required action until completion of the process. Trademark Journal. Trademark Journal is an official gazette of the Trademarks Registry. If a trademark examiner determines that a trademark application can be granted registration, the application is advertised in the Trademark Journal. While the application is advertised, all persons have an opportunity to oppose the registration of the mark. Trademark opposition. As per the Trademark Act, any person can file notice of opposition against a trademark application within a period of 4 months from the date on which the mark is advertised or re-advertised in the Trademark Journal. After receiving the notice of opposition, the application is required to send a counter statement to the registrar within 2 months. Advantages of patent registration. Invention is protected. The patent is an intellectual property which protects your creation, invention and averts or prevents others to use it without your prior consent. Sell or transfer patent. It can be sold and transferred or franchised. By doing this, more revenue can be generated. Patent valid for 20 years. Your invention gets protection for a particular period which helps you to protect your invention. Build business. It helps to build business and also helps in raising capital for business. Royalties. By licensing the patent to other company, royalties can be received by the owner. Monopoly. Thus businesses and investors can have a complete monopoly and competitive benefit. Five easy steps for patent registration. 1. Patent search. If there is a patent already registered which is similar to your idea, then patent search saves the effort of going through the tedious registration procedure. 2. Patent domicile. Patent that is registered in India are only valid for India. It does not apply to other countries. It is also possible to protect invention abroad also. For same You need to apply for a separate application in each country. 3. File patent applicant. An application should be filed with the department before disclosing all the details about your invention. 4. Patent review. The Patent Office of the Indian government reviews your patent application. They check if there are any current patents given or granted on the like idea. If not, then they give a patent for the application submitted. 5. Patent grant. Once the patent is granted, the status of the application will be updated online at the site. It can take approximately 6 months to even 1.5 years for a patent certificate to be granted. Patent registration governing law. The Patent Act 1970 and the Patents Rule 1972 governs the whole of the patent system. Persons eligible to apply. Section 134. An application for a patent for an invention may be made by any of the following persons. By any person claiming to be the true and first inventor of the invention, a natural person being the assignee under patent law and claiming to be the true and first inventor of the art, research in respect of the right to make such an application. By the legal representative of any deceased person who immediately before his death was entitled to make such an application. An application may be furnished by any of the persons mentioned either alone or jointly with another person. What is a provisional patent? To say, the provisional patent helps the inventor, creator to establish initial ownership over its own invention on submitting the provisional specifications of the product or process. The documents necessary to be filed for the permanent patent have to be done or filed within or in 12 months, or else the application so made would be cancelled completely. A provisional patent application is an initial step, before the filing of a regular patent, for procuring a type of interim protection. The option is formed to deliver investors with an economical way to temporarily safeguard their inventions till they decide to pursue a full patent. Advantages of filing provisional patent. Legal protection. Only owners of registered patents are allowed to take action or sue for damages in case of patent infringement. If the inventions are not registered, then the patent protection is not enforceable. Competitive edge. The registration of the patent will provide a unique competitive edge for the business. Other competitors will not be allowed to use the patented invention for similar or same goods or services. Creation of asset. Patent registration creates an intellectual property, which is an intangible asset for an organization. The registered patent is an intangible asset that can be sold, franchised or commercially contracted. Minimal information. There is less requirement to file a provisional patent. Even if your invention is at a conceptual stage, the minimum need is to specify the title, specify the field of the invention, its nature and possible uses to file a provisional specification. Established right early. The provisional patent permits to book the name against owner's invention even before it is final. Evaluate market. The provisional requirement description helps you to scrutinize the market potential of the invention made before taking the final decision of filings for a complete requirement of a patent. Contents of provisional specification. 1. Give title of the invention. 2. Provide short description of the invention. 3. The details of invention contains. 4. It should also mention the background of the invention. 5. Object and statement of the invention. Provisional patent application process. Collecting details of the invention 1 working day. Draft the application based on the details you send in, approximately 7 working days. The drafted document will be filed with the registrar and, on acceptance, the client would be able to use patent pending on your product any time over the next year, approximately 2 working days. Design registration. Design registration is a type of intellectual property protection, under which newly created designs applying to articles created under an industrial process can be protected from counterfeiting. Under the Design Act, 2000, a shape, configuration, pattern or ornament or composition of lines or color or combination applied to any article can be registered. For a design to be registered, it must satisfy the following conditions. It must be new and original. The design should relate to features of shape, configuration, pattern or ornament applied to an article. The design must be applied to any article by an industrial process, and the design must be visible and should appear on an article. Design registration provides the creator exclusive rights over use of the design for a period of 10 years, that can be further extended for a period of 5 years. In case of infringement, the owner of a registered design can seek legal remedy under the Design Act. Republic is the leading business services platform in India, offering a variety of services like trademark registration, business registration, tax registration, tax filing and capital syndication. Republic can help you register or design. The average time taken to draft and file a design registration application is about 10 to 15 working days, subject to government processing time and client document submission. Get a free consultation on filing a design registration application by scheduling an appointment with an Republic advisor. Designs that can be registered. For a design to be registered under the Designs Act, it must satisfy the following 6 conditions. 1. The design should be new or original, not previously published or used in any country before the date of application for registration. 2. The design should relate to features of shape, configuration, pattern or ornamentation applied or applicable to an article. Thus, designs of industrial plans, layouts and installations are not registrable under the Act. 3. The design should be applied or applicable to any article by any industrial process. Normally, designs of artistic nature like painting, sculptures and the like which are not produced in bulk by any industrial process are excluded from registration under the Act. 4. The features of the design in the finished article should appeal to and are judged solely by the eye. This implies that the design must appear and should be visible on the finished article, for which it is meant. Thus, any design in the inside arrangement of a box, money purse or armira may not be considered for showing such articles in the open state, as those articles are generally put in the market in the closed state. 5. Any mode or principle of construction or operation or anything which is in substance a mere mechanical device would not be registrable design. 6. The design should not include any trademark or copyright. Benefits of design registration. All documents pertaining to a registered design are maintained by the Patent Office to put competitors on notice about registration of a design. A registered design provides the creator exclusive rights over use of the design for a period of 10 years, that can be further extended for a period of 5 years. In case of infringement or piracy of a registered design, the owner of the registered design can seek legal remedy under the Designs Act. Anyone found contravening to the copyright in a design is liable for every offense to pay a sum not exceeding Rs. 25,000 to the registered proprietor subject to a maximum of Rs. 50,000 recoverable as contract debt in respect of any one design. Thus, registering a design provides legal remedy against infringement. Important aspects of design registration. File professionally. It's important that a professional file for the registration of a design to ensure that the design is properly protected. An experienced professional can help significantly improve chances of successful design registration by filing a professional application, addressing all the aspects of Designs Act. Government process. Filing a design registration application does not guarantee registration of the design. Design registration is a process and registration is provided only by the registrar, based on the facts and premises of each case. Hence, Our professionals can only make best efforts for filing of design registration application based on experience and expertise. Timeline. Post-filing of a design registration application, it is important to periodically check the status of the application until its processing on the government side. Design registration application process sometimes requires various time-bound response or action from the applicant. Hence, it's important to continually check the status of the application and take required action until registration. Protection. List of all registered designs are maintained and published by the Patent Office to put competitors on notice about registration of a design and prevent counterfeiting. In case of infringement or piracy of a registered design, the owner of the registered design can seek legal remedy under the Designs Act. Tenure protection. Designs registered under the Designs Act are protected for a period of 10 years, renewable by another 5 years. However, design registration mainly applies only to designs applied by an industrial process on any article. Hence, items that are covered under the Trademark Act or Copyright Act cannot be registered as a design. What is copyright registration? Copyright registration confers upon its owner exclusive rights to copy or reproduce the work or allow or give permission to another person to do so. Copyright is ordinarily possessed by the creator of the work. Copyrights are also transferable. Is copyright required to be registered? Copyright registration protects the rights of the inventors in the case of an infringement. This is legal protection that no other can misuse the copyrighted of writer or creator in any form of prescribed work without the consent of the owner. Copyright identifies the exclusive rights of the owner over an original/unique work, such as music, books, development of software, making films, fashion designs, brochures, and training manuals all enjoy copyright protection, even without copyright registration. Copyright protection. Registering the work with the Registrar of the Copyright Office is essentially a copyright protection insurance policy. It produces a public record of the work done, and also you can subsequently sue anyone for copyright violation made. Copyright registration is only considered as prima facie evidence if done within 5 years of the creation of the work. Reasons to copyright registration. 1. Registration ensures legal protection. 2. It also secures goodwill. 3. It also restricts unlawful reproduction of the work of the creator. 4. Global protection, as copyright in India is recognized virtually worldwide. 5. Copyright registration helps in creation of assets, i.e., and intangible assets, and can be sold, franchised or commercially contracted. Just 4 steps in process for copyright registration. Copyright application. Copyright application needs to be prepared and it takes approximately 2 to 4 working days. Processing application. After filing of an application, diary no is issued and then applicant has to wait for next 30 days for objections. Filing. In case of no objection, scrutinizer will examine the application, and if no discrepancy is found, then registration is approved by the registrar. Copyright registration. After the application is approved by the registrar, extracts will be sent by registrar to the applicant. How long does copyright protection last? The copyright protection is valid for life plus 60 years after the death of the creator/author/owner. Work in which copyright subsists. Copyright shall subsist throughout India in the following class of works, i.e., to say, cinematography, film, sound recording, dramatic, musical, artistic work, original, literary, others. Meaning of copyright. It means the special right to do or give consent to the doing of any of the following acts in respect to the provisions of this act, namely, in the case of a literary, dramatic or musical work, which is not being a computer program, to replicate the work in any material form, including the following: to issue copies of the work to the public not being copies already in circulation, to perform the work in public, or communicate it to the public, to make any cinematography, film or sound recording in respect of the work, to make any translation of the work, to make any adaptation of the work, to do, in relation to a translation or an adaptation of the work, any of the acts specified and others.